Honor, Mr. Weldon is present before the court.
Okay, thank you. So this is a review of a district court bail that was set at $2,500, I believe.
Yes, sir.
Correct. Okay. So would you like to be heard?
I would, Your Honor. Thank you very much. Bail was set in this case entitled 1723-7624 on 10/17, the amount of $2,500. This is Mr. Weldon's request to reduce that bail to $150. I've taken a look at the reasons for bail, Your Honor, and I would like to address them if I may.
Go ahead.
First and foremost, Mr. Weldon's ties to the community can be described only as significant. He has lived in Springfield since 2001. He lives with his mother in a house that she hopes one day to own and then pass on to him. He hopes to raise his 1-year-old daughter in that house and his as yet unborn son, due on December 27th. He is currently taking care of his daughter, Jasmine. This is his entire reason for being here, and he's not going anywhere because of that. I would also like to address his, I'm sure the Commonwealth will discuss Mr. Weldon's past record, so if I may address that.
Sure.
Note, in the past 10 years or so, he has, I believe, 5 defaults, 3 of which were monetary and 2 of which I understand were related to him moving from Westfield to Springfield. So just did not get notice of the court dates. In the past 10 years, he has not willfully failed to show up for court, and before that, I believe it's still a few more years before you get to further record. But more importantly, Your Honor, I think all of this record occurred before, again, Mr. Weldon became a father for the first time. This has dramatically changed his outlook. This has dramatically changed where he's at in his life and what he's interested in doing. And he is currently very much interested in fighting this case, which brings me to the facts and circumstances of the case. The allegations here that Mr. Weldon fled from police, allegedly drove his car at police officers, and then failed to stop, and then eventually crashed his car, at which point he was subdued by the police. In the course of being subdued, the police managed to break 2 of his ribs, his wrist, his elbow. He has taser marks going from his shoulders down to the back of his thigh. He spent the night in the jail before being sent to the hospital, at which point he was also told that he has apparently a growth on his back, which will need to get checked out. He has still not received medical attention for it. As you can see, Your Honor, he has a wrist brace. This has been the extent of his medical attention for the time that he's been here.
I find that unfortunate, but I'm sure the other side's going to tell me if he just stopped, he would have been arrested for operating after suspension instead of a felony and having broken ribs because he resisted arrest, allegedly. That's the other side of that coin. So the real problem is his record and some history of defaults. He's got an incentive to flee because he's been convicted for these things in the past, and also because he's a known flight risk because he did flee on the day in question. These are the issues. How much did you say you could post?
150. If I may address his financial circumstances, Your Honor.
Sure.
Mr. Weldon survives on $750 a month SSI, $550 of which goes to his mother for rent and help with the bills, the rest of which goes to feed himself.
Why does he get SSI? Is he disabled?
My understanding is severe ADHD. He has some cognitive difficulties. I'm still doing a little bit of background research of that and getting medical records.
Dyslexia too.
Dyslexia too, as well.
Yeah.
Although Mr. Weldon is insistent that he's mostly worked warehouse jobs in his life, physical labor, things like that. and he's looking forward to doing that again when he gets out. The $150 is hugely significant to him. It is literally food out of his daughter's mouth. And so we would suggest, Your Honor, that that's an appropriate amount of bail to ensure his return to court.
What's the situation with the car? He manages to get behind the wheel pretty often for a guy who doesn't have any money.
He does live with his mother, and it was a car his mother had recently purchased that he was...
Maybe she could help out with some bail. All right, I heard what you said. The financial situation is very restricted. If you didn't have this record, I would do it. But I don't see that his past performance is indicative of a lot of confidence in him being compliant with court orders. That's the only thing. What are you asking for?
Your Honor, the Commonwealth, quite frankly, thinks that a $2,500 cash bail is low for the facts and circumstances, and a defendant with this type of history with the court and his record, and not only his record of this same type of behavior, but also his record of defaults. I've counted more defaults than the defense counsel has indicated. There are several defaults that appear in his record, not only monetary, but defaults that appear even when he's facing a violation of probation. And he indicated that he came to Springfield in 2001, and his record starts in 2002. So it wasn't very long after he came to Massachusetts that he started amassing what I would suggest is a significant criminal history. And when you look at his cases, he's defaulted on the cases in which he clearly was not held on bail. And then you look at more recent cases, and you look at the dates in between his arraignment date and his next date set, which is within a month of each other, which is usually the date set for individuals who are held on bail because they're brought before the court usually within the next 30 days. This defendant has 2 fugitive from justice complaints that are on his record. Those fugitive from justice complaints are dismissed once a defendant is then brought to this jurisdiction from which he was a fugitive. So the fact that they are dismissed, what is more significant is that they were brought against this defendant. So he has 2 fugitive from justice complaints from 2008 and 2006. He has true name violations that appear on his record as well, indicating, again, his attempts to not answer to his charges and to the court and to face his record. And that was in 2006 and 2003. He's been sentenced to significant time in the past for these exact types of behavior. In this particular case, Springfield police officers were trying to stop the defendant who was in a motor vehicle because they had a report that he had assaulted a female. And the defendant did not stop. There was a multi-cruiser chase of the defendant throughout many streets in Springfield, and he drove directly at more than one cruiser, and police officers operating more than one cruiser during the course of that police chase with the defendant. Ultimately, the defendant did crash his motor vehicle, but that still didn't even stop him. At the point in time that he crashed his motor vehicle, he climbed out of the passenger side window and then began running from the police. The police eventually were able to stop him, at which point he continued to resist arrest as well. And on his person, he had actually in his hand that was clenched, I believe he had a knife that the police officers were able to secure after placing him in custody. This defendant also has an out-of-state record out of the states of New York and New Jersey. So I would suggest that at this point, the defendant fled to avoid apprehension on the date of this offense. He has the same type of offenses on his record in the past for assault by means of dangerous weapons, operating recklessly, assault with a dangerous weapon to wit a motor vehicle, and that was in 2010. He has assault and battery on a police officer, where he was sentenced to 1.5 years in the past. He has a number of defaults. I counted at least 6 defaults that appear on his record, as well as the fugitive from justice charge and the true name violation. The Commonwealth has no confidence that this defendant would return to court after going through the significant means that he went through on the date of his arrest to avoid apprehension by the police.
You want to respond? Go ahead.
If I may, Your Honor, thank you. We don't deny that Mr. Weldon has had issues in the past. I mean, the linchpin sort of this is the fact that, again, he is a boss now. Running from this charge means running from his child, the child he is taking care of, and currently is in the custody of his mother, who works and is back in the position of being a single mother. But more importantly, the Commonwealth's allegations are simply that. They're allegations at this point. We have, submitted a couple of FOIA requests and received the IIU records of some of the officers involved. There are significant use complaints. We'll be investigating over 40 of them. And this is going to take some time. Mr. Weldon wants to fight these. He was badly treated on the day of his arrest, and he wants to fight back. It's going to take time to do this well. And for that, Mr. Weldon, to properly assist, needs to be out and helping. He will return to court. We are confident that we can beat at least some of these charges. And so for that, Your Honor, we'd suggest that while we acknowledge the past history, this case is different. This time is different. And bail should be set at $150.
Unfortunately, I think that's too low to guarantee his appearance. I'm going to set cash bail at $1,000, which I think is eminently reasonable on the facts and his demonstrated prior record, which is very bad. And if he does post that amount, I will set a GPS condition of home confinement and no windows. And although it's redundant, I'm going to say no operation of any vehicle. Of course, he can't do that if he's confined to the home anyway.
If I may, Your Honor.
Yes.
Supposing Mr. Weldon is able to post $1,000, he is interested in gaining employment in the future.
He hasn't to date, right? I mean, he's. You keep talking about he's supporting his daughter, and he's content to receive the $750, although he told me he could work at warehouses and things like that. If he gets employment lined up, he can petition for the windows to open up. Otherwise, I don't want him just roaming the streets ostensibly on the guise of looking for employment. If he can get his old job back and you want to petition, you can. But so I'll set the home confinement without prejudice. Maybe he can take care of his daughter and alleviate some of his mother's obligations.
Thank you, Your Honor.
Thank you, Your Honor.